ever consciously appreciate the fundamental rights that you have? For instance, the right not to be discriminated, or the right to freedom of religion and thought, or the right to freely move around the European Union. Probably you do not, because in our society it is more likely that those rights are respected rather than that they are violated. But what if somebody violates your fundamental rights? Probably then you will feel sad, disappointed, stressed. You wouldn't know what to do. To console you, in principle, where there is a right, there is also a remedy in case the right is violated. But what if your lawyer tells you that in your specific case, there is no clear remedy in sight? To experience this problem, I'm going to ask you to vividly imagine the following situation. You are a passionate mountaineer with a lot of experience worldwide. You've been working as a doctor, a history teacher, a psychologist, sociologist, biologist for years now, and you decide to turn your hobby, mountaineering, into a career. Besides, you've been studying Spanish for several years now, and you master that language almost as if it is your native language. You decide to apply for a job as a guide in the Sierra Nevada. But the travel agency that offers the job refuses to hire you, only because you do not possess the specific language certificate that they require to prove your Spanish language skills. That specific certificate, however, can be obtained only by Spanish citizens. So, the travel agency discriminates you for not having the Spanish nationality. With this, the travel agency infringes or violates the right to non-discrimination and the right to free movement of workers, two fundamental rights in European Union law. But European Union law does not provide for any remedy in case these rights are violated. How do you feel? Doesn't feel just, does it? What are you going to do? If you don't feel much yet, and it takes a bit more to upset you, I'll give you another situation. You are religious, or if it's easier to imagine, you are a strong supporter of a certain political ideology. Every day, or almost every day, you are wearing symbols expressing your religion or political ideology. So, for instance, you're wearing a necklace with a little crucifix, or you're wearing a kippah, or a turban, or a headscarf, leaving the face uncovered. You are working for a private company, and in your function, you frequently have face-to-face meetings with clients. At some point, the company adopts an entirely neutral dress code policy, prohibiting religious and political symbols of any kind. As you want to stay true to your religion, or to your political ideology, to your identity, you refuse to give up wearing these symbols. But guess what? You're dismissed. How does that feel? Does that feel just? Is the private company allowed to adopt and enforce such a dress code policy and to dismiss you? Or does this dress code policy and the dismissal violate the right to freedom of religion and thought, and the right not to be discriminated on the basis of your religion and political ideology? Some of you may have very strong feelings about these cases. Others may be entirely confused. Now, let us switch perspectives. You are no longer the refused job applicant or the dismissed religious employee. Now you are the judge that has to deliver a decision on these cases. What are you going to do? Raise your hands if, for the first case, raise your hands if you think that the refusal by the travel agency is unacceptable, is unlawful. Raise your hands if you think so. raise your hands if you think that this refusal is perfectly possible and should be accepted. None of you. Interesting. Then for the second case, who of you thinks that the dismissal and the dress code policy of the company is unlawful? So it's not acceptable. Raise your hands if you think so. Who of you, raise your hands, if you think, who of you thinks that the dismissal and the dress code policy are actually acceptable? Ah, there's a difference here. That's interesting. I think still majority thinks that it's unlawful, and so was for the first case. We can come back to this later. The situations that I sketched are actually real cases dealt with by the European Court of Justice. One was decided 16 years ago, the other is still pending. We're waiting for a decision. If the European Court, or in cases in which the European Court of Justice decides that such conduct by private parties violates European Union rights, a next question pops up. What are the concrete consequences of such violations of European Union law by private parties like, for instance, the travel agency or the employer? And which remedies can be used? And this is exactly where my PhD research kicks in. In most cases, European Union law doesn't say anything about remedies or consequences for infringements of European Union rights. In case a private party infringes European Union rights. So the legal practitioners dealing with these cases, they don't have a clear paved path to steer onto. In that respect, a civil judge in one of the member states once said that European Union law is like a country behind the mountain. So you know that it's there, but there's hardly any connection. And that lack of connection is a problem, because European Union law aims at stimulating the internal market and employment, and also protecting fundamental rights. So we urgently need to find a route that connects European Union law to private law of national origin. So you have to find remedies and to connect them. In my PhD research, I am analyzing how European Union law can intertwine with private law of national origin, how to cross that mountain, and to climb it, and to provide for connecting routes. So, for instance, in your cases, or in the cases that we sketched, in the case on the refusal by the travel agency, which constitutes a violation of the free movement of workers and the right to non-discrimination, national private law can determine that the requirement is invalid and that the refusal is unlawful, so that the travel agency can be held liable to pay damages to the refused job applicant. Whereas in the second case, national law could provide for a provision which determines that the dismissal is unlawful and that the dress code policy is invalid, and then the company has to either take back the employee or to pay compensation for damages. And these are just two examples, but in my PhD research I provide for many more examples. And I'm trying to finish my PhD over the next few months, but I'm sure that after that there will be a lot of pioneering work on the horizon. Thank you.
Thank you.